Now let us proceed to the UNITROID Principles of International Commercial Contracts or PICC. So the UNITROID, or the International Institute for the Unification of Private Law, is an intergovernmental institution located in Rome, Italy. So among other initiatives, UNITROID has played a prominent part in initial efforts to harmonize law of the sales contracts. So the PICC are one of the most outstanding accomplishment of the UNITROID, which the project originated in 1971. So, a group of three legal scholars who specialize in comparing and contrasting different legal systems played a key role in developing the initial drafts of the PICC. So, in terms of the civil law, which it emphasized the codified statutes and legal codes, so it is represented by Professor David. In terms of the common law, which relies heavily on the judicial precedent and case law, it is represented by Professor Smithoff. And in terms of the social law, which focuses on the state ownership and social welfare, it is represented by Professor Popesco. So in 1980, the working group took over, which was chaired by Professor J. Brunel of Italy. So the composition of the group has evolved over the years, and PICC strives to incorporate principles and concepts that are compatible with the major legal traditions or legal systems that governs international contracts. So the PICC is the principles in which they are used for reference. So parties involved in the international sales contract can choose to incorporate the PICC by reference in their agreement. So this makes PICC as a governing framework for interpreting specific agreements between parties. So they don't hold legal binding force over the parties to contract, which means they are not automatically or um, mandatorily applied in the contract. So they are only applied when it is agreed by both parties involved. So in situations where an international contract doesn't specify a governing law, the court might consider the PICC as a source of guidance to fill in any legal gaps and interpret the contract terms. So it consists of the codification of the general law of contracts, where the provisions themselves, the so-called black letter rules, are followed by comments and illustrations. So the black letter rules are the actual provisions or the rules of contract which specifies the rights, duties, and obligations of the parties to a contract in a various situation. So may mga comments and illustrations siya that provides further clarifications, interpretations, and context for understanding the rules. So this provides a practical guidelines kung paano i-apply ang rules in a specific situations. So they have been conceived as a soft law instrument with no normative value. So soft law instruments are not legally binding as the same way as the national legal system. So they are typically the non-binding guidelines, recommendations, the principles. So normative value is what is determined naman to be normal, expected, or usual. So PICC has no normative value, although they offer suggestion for good practices in the international contracts. They don't dictate what must be done or expected to be automatically used. PICC are simply published as a book. So anyone involved in the international business can access and use the information contained within these principles. So there are no restrictions on who can read or reference them. So the nature and possible uses of the PICC are stated in their preamble. So in terms of the contractual choice, if both parties explicitly agree in their contract to use PICC as the governing rules, then those principles applies. So, in terms of the general principles clause, PICC acts as a recognized and respected set of guidelines that can be used to interpret what those general principles or lex mercatoria or merchant law actually mean in the context of a specific contract. So, if no choice of law where the contract is silent on which law applies, the PICC potentially fills the gap and provides a framework for resolving disputes. So it supplements international laws. So PICC can be used to add details or to clarify ambiguities in this existing international laws. So it is also used to supplement domestic laws. So even when the domestic laws applies to a contract, PICC can be a helpful source for the judges and arbitrators to interpret the laws and fill in any gaps where PICC serves as a supporting document that reflects common practices in international commerce, making national law application more relevant to the international context. So it serves as a model for future laws. So the PICC can serve as an inspiration for lawmakers both on the national and international level when creating new laws related to international commercial contracts. So many countries, including the France, Germany, Hungary, Russia, and China, um, are using PICC as a model when revising and creating their own commercial contract law. So the first edition of PICC came out in 1994. The second edition, published in 2004, added new chapters such as the authority of the agents. So this chapter likely clarifies the rules uh, around who can act on behalf of another party in the international contract. Next is the third party rights. So this chapter likely deals with a situation where someone not directly involved in the contract have rights or obligations arising from it and set off. So this chapter likely clarifies or explains how a party can use the utang of the other party sa ila to reduce kung anong ila utang under the contract, the assignments of rights. So this chapter likely to clarifies the rules around transferring the rights under a contract to another party. So next is the transfer of obligations. So similar to the assignment of rights, this chapter likely explains how the obligations under the contract can be transferred to another party. And lastly is the assignment of contracts and limitation period. So this likely combines the two separate topics. So in terms of the assignment of contracts, it addresses how an entire contract with both rights and obligations can be transferred to another party. And in terms of the limitation period, it refers to the specific time frame with which legal claims arising from the contract can be brought to the court. The third edition, issued in 2010, brought innovation mainly on the subjects on the validity of the contract, restitutions, which deals with what happens when the contract is found to be invalid or is breached. And lastly is the conditions and plurality of the obligers and obligees. So this is a more complex topic in terms of the condition. It specifies the obligations of the parties that they need to met in terms of the plurality of obligers and obligees. These refer to the situation where more than one party on each side of the contract, such as the multiple obligers owing something and multiple obligees entitled to receive something. So PICC 2010 now consists of 211 articles, which have 11 chapters, which successively deals with the general provisions, formation of authority of agents, validity, interpretation, content, and third-party rights and conditions, performance, non-performance, set off, assignment of rights, transfer of obligations, and assignment of contracts, limitation periods, and the plurality of the obligers and obligees. Lastly is the PICC and its application in the international sales contract. So compared to the last two instruments, PICC are not especially designed to regulate sales contract. So the PICC are rules applicable to commercial contracts in general. So they have been devised to govern any types of contracts, not only specific to sales. So but they can also be applied sa lease, construction, distribution, transfer of technology, or outsourcing. So PICC commonly states rules concerning mainly on the formation of contracts, performance and non-performance of contracts in general. CISG naman are general provisions which which are applicable to any contract for international sales of goods. So it involves the formation of sales contracts, the obligations of the sellers and the buyers, the available remedies, and the passing of risk, as well as some provisions common to both parties. Incoterms naman are also specific to sales international sales contract, but they are limited mainly to delivery of goods and passing of risk. So PICC, Incoterms, and CISG are complementary with each other, so they can work together or complete each other in a useful way. So the subject matter ng Incoterm overlaps with some provisions of the CISG, since CISG also deals with the delivery of goods and as well as the passing of risk. So in such context, the choice of an Incoterm is perfectly compatible with the application of the CISG, where the Incoterm can replace corresponding provisions of the CISG, specifically in terms of the delivery of goods and the passing of risk. But CISG still has a wide field application on the contractual relationship, which all of its provision can deal issues not covered in the Incoterm, such as, for example, the formation and payment, the remedies available for both parties. So CISG may have covered many aspects of contractual relationships between the seller and buyer, but not all. So CISG is not concerned, for example, with the validity of the contracts, the authority of the agents, the interpretations of the contracts, or the plurality of the obligers or and obligees. So at the higher level generality, these matters can be covered in the PICC. So if the parties wants to benefit for a complete set of rules to govern their sales contract, they can choose to agree that in addition to the CISG and the possible choice of Incoterms, their agreement can also include the rules of PICC.